Hello, and welcome to the Law Deals podcast, where we help law firm owners create succession plans, profitable partnerships, and seamless practice transitions. We're on a mission to help you build a firm where it isn't dependent on you. You can choose who you work with and what you do, and you can convert that firm into retirement security to maximize the financial return on your life's work. I'm your host, Ed Alexander. I'm a transactional business lawyer with 31 years experience and the owner of two businesses, Alexander Business Law and FitzGibbon Alexander, both serving law firm owners. This episode was inspired by a real-life story. The proverbial landmine that you're going to hear about today exploded on a successful surgeon, but it's one that exists in many law firm and small business partnership agreements. And I cannot stress enough how dangerous this landmine is and how you need to deal with it right away if it's in your partnership agreement. So let's get into the story. So this is a story about a surgeon who was one of 4 surgeons that owned a practice. It was a thriving practice, generating millions and millions of dollars per year. So unfortunately, this surgeon developed a condition where his hands began to shake. And obviously, control over your hands is essential for a surgeon. So as this got worse and worse, the surgeon started thinking about, well, hey, I'm not going to be able to do this anymore. But he felt like he was covered because his practice had bought disability policies and had a buy-sell agreement. So the goal or the expectation was that the disability policy would pay the proceeds and the practice would buy out his interest. However, when he reviewed the shareholders agreement, there were several problems that came up in the shareholders agreement. The first is, and I'm going to get into this in detail in this episode, this is really what this episode is about, is the value definition. What was the value that the practice had to pay for this surgeon's interest in the practice? Second was payment. When did the practice have to pay it? And then the third was, what are the conditions of the policy that backed up that payment obligation? Now, in this case, just to make sure that we understand, this is a surgeon who, like many business owners and professionals, believed that this was covered, that he was in good hands, and that if something came up, he had paid for years and years for insurance that would take care of him and his family. And unfortunately, as we're going to find out, that wasn't the case. So we're going to circle back around this when we talk about the various issues that come up. But I will tell you that the primary issue that we're going to look at here is the value problem that this represents. His shareholders agreement only required the law firm to pay book value. And so value is such an important thing. I felt like we needed to have an entire episode devoted to it. But I definitely am not an appraiser. So to help me this discussion, I'm joined by Matt FitzGibbon. Matt was previously on the podcast, and you'll recall that he is an ASA, or American Society of Appraisers, senior appraiser. He's a Florida licensed real estate broker, and he's also my co-shareholder at FitzGibbon Alexander, Inc., our business brokerage, valuation, and transactions consulting firm. So let me welcome Matt to the podcast. Hey, Matt, welcome to the podcast.
Thanks, Ed. It's great to see you today.
Great to talk to you. All right. So you heard the story. You know what the situation is. All right. We're going to talk about value because that obviously is your bailiwick. The problem with that story that we just talked about is obviously the first to leave loses big time. Because once everybody figures out the disaster that's in there, then they redo the agreement for every other partner, right? And so the first guy out loses. So let's talk about when value is relevant in a partnership agreement, right? I think that I look at this in the context of entrances and exits or on-ramps and off-ramps, right? And so the list that I would just come up with off the top of my head is, anytime you're adding an owner, right? Naturally. Anytime an owner dies, right? Assuming that you want to buy that owner out and not just have his spouse or her spouse and kids as your partners, which to me would be a disaster anyway. And of course, in the law firm context, we can't do that, right? Because in law firms, except for certain states, Arizona, and even though there are certain restrictions, you can't have a non-attorney owner of a law firm yet in most states, right? I say yet because I think it's ultimately coming. But then you have also disability, a voluntary departure, termination. So, there's a breach of some obligation, right? In which case you might be kicked out. And then there's retirement. And then, this concept of selling the firm entirely. So the two key factors here for these really are how much to pay and how to pay it, right? So the first thing I want to get with you, Matt, is tell us the difference between price, cost, and value, because I think that weighs in on this.
It's a good question. Well, price and cost are simply numbers. Value is obviously something that is what we're trying to get to. In fact, we typically use price and cost are two sides of the same coin. And we typically use price when we're talking about an advantage. Like, you wouldn't believe the price on that thing. Like, wow, I'm going to get more value than what they have it priced. And we use the word cost when we feel like we've sacrificed or we haven't gotten the value we feel like we deserve. Wow, that steak dinner at the new steakhouse set me back, cost me $100 last night. We kind of use those two terms to kind of express whether we felt like we got an advantage on the value or we had to sacrifice on the value. But they're really pretty much the same thing. The value is what we're trying to get to. And that value is going to be viewed differently by different people and in different circumstances.
So I've always looked at it, and I've heard this many times where somebody says, well, I want to sell my business for $1 million and it costs me, $750,000 or whatever. I'm just picking numbers, of course. Right. And you look at the numbers and you say, well, yeah, but it went down in value because it's not performing as well or whatever, any factors that you factor in there. And so, when we look at the concept of value, the cost to acquire, it's not really a variable that we're looking at right here is how much
at all
pay for it.
Yeah, the amount that somebody paid for the business interest or paid for an asset really is oftentimes irrelevant to what the current value of the business is.
Okay.
Sadly, for most people.
Yeah, sometimes it can be a tough conversation to have. All right,
yes.
So let's talk about value standards, right? Because in the story that I relayed earlier, the surgeon was being bought out at book value. So let's start with that. What is book value?
Book value is simply an accounting term. And it's basically the historical cost that you paid for something, subtracting all the amortization, depreciation, or impairment. But it's an accounting term and it's accounting method, but it may have absolutely, and in most cases has absolutely nothing to do with the current value of a business interest.
Right. So if I buy a computer, for example, right,
mm-hmm.
as a small business owner under the tax code, I'm entitled to a deduction for that cost right away under Section 179. Yes. So from my perspective on my books, that value then that computer has zero book value, right?
Mm-hmm.
And so even though I could turn around and sell that and maybe get half the price I paid for it, right? So book value in that context, what you're saying is it's likely to have no correlation with actual value whatsoever.
Yes, that's correct.
But the benefit is it's easy to look at it and say, mm-hmm. oh, it's just a quick calculation. I can do that easily, right?
Yes.
All right. So now we got book value. And right now I'm imagining that if you listen to this, you're hearing the surgeon story and you're going, oh my God, this is a multi-million-dollar business. And now yep. I'm getting pennies, if pennies, maybe even less than pennies on the dollar of that value, right? Because it's all dependent upon the depreciation schedule we adopted and when we bought the equipment, and none of it right, has to do anything with what is the true value that somebody would get if they came into this business, right? Or if they acquired the business and got the cash flow. All right.
That is
So
correct.
let's talk about the next one, which is what most people are talking about, which is fair market value. Tell me about fair market value.
Fair market value is under the premise of value exchange. We're assuming that there is a market for the interest that we are valuing, and that everybody has reasonable facts everybody has the same facts about that interest. So with fair market value, that usually comes under a value of exchange premise of value. And it's also typically going to be used when we're valuing business interests for gift and estate tax purposes and things of that nature.
So what I'm assuming is that somebody can sell it, that somebody's interested in buying it, and that they understand what's involved in owning that interest, right? So I fully understand all the good, the bad, and the ugly about that business itself. And that comes into fair market value. So now we understand fair market value. Let's talk about another term that I've heard and seen used, and that's fair value. Tell me what that is.
So fair value is a standard that's used pretty much along the lines of financial reporting. That's where you most often see that. And typically, again, we're trying to stay in general level terms here at this point. Fair value is going to be valuing the entity and looking at everything on a pro rata basis. It's not going to consider discounts for lack of marketability and control and premiums for control, interest and things like that, which we will apply to the fair market value standard depending on the circumstances and who the intended users are and where it's going to be used.
Okay, great. So now we have the IRS standard, fair market value, and I guess really market standard. We have fair value for financial reporting purposes. And now we get into what I've used myself several times, and I'm sure anybody who has seen this before, is a most probable selling price. How does that differ from the others?
Most probable selling price is a term that, as far as I know, going back 25 years or so, came out of the International Business Brokers Association, or the IBBA. Most probable selling price is a term that business brokers use. And the difference between the definition of fair market value and most probable selling price is this word compulsion. In fair market value, we are assuming that the parties to the transaction are under no compulsion to purchase the business interest. The interesting thing about that is, if no one's compelled in any way, why would they be doing the transaction in the first place? So if we wanted to get into the weeds, there are some issues with fair market value if we get into it. Well, the IBBA in the business brokerage world says, well, everybody who does a business transaction is acting on some type of compulsion. They're looking for some purpose to do this transaction. And when they do the transaction, they're anticipating to get a greater value for what they either bought it or they sold it for. So the IBBA has this term, most probable selling price, and it's basically the fair market value without reading the definition. But it assumes that there is compulsion on the parts of the buyer and the seller, and it's most often used by business brokers and in pricing opinions.
Excellent. Okay. So those are some types of value, right? Let's talk about how we get to those, right? So in this case, in the surgeon situation, right, we got to it by looking at the financial statements, right? And so in other agreements that I've done and reviewed and worked with, we've had things like an agreed value where we put together a certificate and say, hey, that's the value that we agree upon as partners. There is the process for securing an appraisal. There is the auction process. There's formulas. And I guess a subset of formula would be kind of rules of thumb, right? So let's kind of just talk a little bit about those mechanisms. So I think I touched a little bit on agreed value. The reason that I've worked with people who use agreed value is that it's easy. We can just sit around a table and agree on a number and everybody's happy. Now, that number may or may not have any bearing on reality, and many times it does not have a bearing on reality. Now, one of the things you need to know is that if that's in your partnership agreement, then it's essential that that certificate have an expiration date, right? Because again, what we've seen is somebody comes in, and I looked at this the other day in a law firm partnership agreement, where the partners agreed that if there was a death, the buyout would be $25,000. Well, that's what they both put in to start the firm 15 years ago, right? And there's no correlation with value today, right? So again, it's easy. That's great, but let's make sure we protect against it. So let's talk about appraisal, right? So I know there are different types of appraisals that you can conduct. Why would somebody want an appraisal in their partnership agreement? What type of appraisal should they use, and what's kind of an idea of cost to get that appraisal and timing?
Okay, great questions. Ed, I tell people that almost every phone call I get starts with, my attorney or my accountant told me to call you. I need a business valuation. I have two questions. How much is it going to cost, and how long is it going to take? And I give the answer to all of them that nobody wants to hear, which is, it depends. It really, truly depends on a couple things. It depends on the intended users, and it depends on the purpose. Those two things will drive what form of report we're looking for and how long it's going to take and what the cost is. So for instance, if somebody says to me, I need a valuation on my business because my partner and I are suing each other and we're going to court. Well, in that particular case, you're going to need a full business appraisal that complies to the Uniform Standards of Professional Appraisal Practice, or otherwise known as USPAP, because the courts expect any business appraisal or evaluation of a business interest is going to meet the standards that are set forth by USPAP. So that will drive then the appraisal report that you're going to need, what it needs to comply, how comprehensive it needs to be, how long it's going to take, and that could take 6 weeks to 2 months, possibly. All depends on the amount of information and what's involved in that. On the other hand, if somebody calls and tells me, I just need an idea, I'm doing some estate planning and I need an idea what the value of my business is. Okay. Well, in that particular case, we don't have to do a comprehensive report that takes as long and it costs as much. And an appraisal report could cost anywhere from $5,000 to $10,000 to $15,000 or more $1,000, depending on the intricacy of the business interest being valued. And which is the other reason why a lot of times people will say, well, I just want to know what the value of my business is. Well, in that particular case, I just need an opinion, a real quick opinion. In that particular case, what we usually do is what's called a broker opinion of value. And it's a less comprehensive, more limited form of valuation. And we put that together, but it does not comply to the Uniform Standards of Professional Appraisal Practice. It does not apply in a court situation in front of the IRS or the SEC or some governing body. And it's more applicable to the person who's just looking for market value to get an idea if they sell their business or what they should include in their estate plan for the value of the business.
Excellent, excellent. So, and the broker opinion of value is also called a pricing opinion. So kind of that, and it really focuses on that most probable selling price more than coming up with that fair market value, right?
That is correct.
So pretty much, pretty significant distinctions there. All right. So now in terms of the other mechanisms, right, we have an auction. An auction's easy, right, because it's the shotgun provision. We no longer want to be partners with one another. I shoot you an offer, right? So I'll buy your interest out for $100,000. And then you have some limited period of time to reply back to me to either accept or swap that offer. So in other words, you buy me out on the terms I propose to you. Or the other alternative is we have an outside party. And we see this a lot in agreements. People are relying on this right of first refusal where if I'm unhappy, I go out and find somebody who will buy my interest in the business and then offer it to you first before I sell it to them. The problem with that is nobody wants to buy into a business, especially if you got a minority interest. Nobody's going to buy into a business where the partners are unhappy with one another and fighting. And, I'm telling the buyer, oh, my partner's a schmuck, that kind of thing. So really that option is not an option. And then the business blows up anyway. So there's auction. Okay. Now let's go to formula, right? So there are rules of thumb, formulas that you can use for various types of businesses, right? That are out there. What are your thoughts on formulas?
I think there's a lot of problems with going that route because a formula is strictly quantitative. We are taking quantitative inputs on the performance of the financial performance of the business, but we're not considering any of the qualitative elements of the business. For instance, what if we use last year's performance, but last week we also got notice that our number one client, who makes up 30% of the business, just died and is going out of business? Well, the formula doesn't take that into account for the future year, and that's what the buyer is buying into, is the future performance of the business. So there's a lot of problems with the formulaic methods, but that's just one illustration of why I wouldn't use those.
Yeah, I think the other side of it is if the business happens to change, right? So if we start out in one business, the example I always give is we're a gym, right? So it's a membership oriented. There's several formulas out there to value a gym, which is great. But then we decide, oh, wait, it's much more valuable and profitable to become a personal training location, right? So we have personal trainers and the gym is just a side component of that, right? So those are totally different businesses and have totally different values. But if you stick that formula into your partnership agreement, the reality is you're stuck with it unless everybody agrees to change it, right? And therein lies some base problem here, right? Because once we put it in the agreement, whatever we're doing, we're stuck with that. And if circumstances change, if somebody's not happy, if somebody gets ill and we know that a buyout is on the horizon, we're not going to be able to go back to everybody and fix this and make these problems go away.
Right. And getting back to your gym example, the formula doesn't take into account the age of the equipment, how much of the equipment needs to be replaced next year. What about the lease on the gym? What if the lease is up in 90 days and the landlord is going to increase the rent substantially or isn't going to renew the lease for the tenant? There's so many elements that go into the future value of that business. And the formula just doesn't take any of that into consideration.
Right. So I think that's a really good point, because we get to what is the value determination? Everybody wants to know what the multiple is, right? That's kind of what they ask. What's the multiple? Multiple of gross revenue or multiple of cash flow, which they don't specify cash flow. But really there's two main variables. It's what is the cash flow, depending on your measure. And then the second is the risk of that cash flow continuing into future. And that's what most buyers are really looking at, is what's going to happen. So when we look at this and we're coming up with value, right? I think, we're making certain assumptions in that value determination, right? So it's number one, is it a going concern, right? Or is it going to change? Number two, what happens if now we're talking about a working owner? So in the story we relayed earlier, the surgeon was actually doing medical procedures, right? So now that surgeon goes away. How do we have to address that in this concept of value?
All big questions, because that whole going concern issue is different for different business types. I know we're mostly talking about private practices here, but for instance, a going concern of an accounting practice is very high as a going concern. But if you're liquidating the assets and you look at the liquidation value, it's pretty much non-existent. Versus a driving range, or if you take a golf driving range, the going concern value is a multiple of their cash flow, but it's probably more valuable if you look at it from a net asset value on the property and the redevelopment of the land. So looking at every business, and in the private practice world, is it a going concern and can we keep this business going? Or is the owner going to just close the business and do an orderly liquidation over 6 months to a year? Or if they die or they leave suddenly due to health reasons, then we have a forced liquidation. All of those things are going to affect the value substantially.
Right.
So the going concern in maintaining that value in a private practice is really paramount to keeping the value as high as possible.
The next issue that comes up is this concept of non-compete, non-solicitation, restrictive covenants, right? So if, in our example, the surgeon leaves and sets up a practice down the road, well, the practical effect of that is that the surgeon is taking value out of the business, right?
Mm-hmm.
And so we've got to address that. And for lawyers in particular, right, we can't have non-competes. So I can, leave a practice and I can go set up the next office over and take the clients with me. And so when I'm getting bought out by my partners, they have to take that into account. And sometimes it even ends up that the liabilities are the most important thing, because now let's say that we've got an office and I'm taking associates and I'm taking paralegals and I'm taking staff members. We have a 10,000 square foot office and now we only need 2,500 square feet. That's a problem, right? And
yes, it is.
And the partnership agreement has to take into account that risk and what's the impact, right? So in those instances, the departing partner might actually have to write a check to cover some of the expenses that have been incurred based on the expectation that they will remain with the business. So it really does impact things in a dramatic way, knowing what's going to happen after this all is over. So
those are all substantial risks. And that's why they should call you, Ed, to help them navigate through those risks, because those are real. I mean, we talk about them, but we don't do that to scare people. We live every day watching these things happen. And it's sad and it's unfortunate, but helping people navigate these issues before they happen is far easier than helping people navigate them as they're happening. So I appreciate
No, absolutely. Making sure that everybody is on the same page. I mean, and through my career, my way of approaching these partnership agreements has differed substantially, right? To the point now where somebody comes and say they want a partnership agreement, I'm not doing anything until we sit down and have a good long conversation around all of these elements, because most people think a partnership agreement is about a buy-sell, right? So you die, I buy you out, right? Vice versa. Some people don't even have that. But at the end of the day, it's so much more because of this ongoing relationship and the impacts that the various assumptions of the parties have really is essential. So I want to pivot for a second here, because this leads me to the issue of enterprise value versus equity value, and the concept of really personal goodwill and enterprise goodwill. Okay, so let's just talk a little bit about enterprise goodwill versus personal goodwill.
Okay, so the illustration I always use is if I walk into my local McDonald's and I get a cup of coffee and some guy comes to the counter and says, "Hey, I'm the new franchise owner. I just wanted to introduce myself to you." I don't much care. I just want a cup of coffee. So whoever owns the business or is operating behind it doesn't matter a whole lot to me as a customer. Although when we're talking about doctors, attorneys, accountants, these are people we have relationships with. So if you go in to see your doctor and all of a sudden somebody new comes through the door and says, "Hey, I'm your new doctor," it throws you. You go, wait a minute. What about my old doctor? And where are my records? And do you know my history? And do you know why I'm here? And it throws people. So these practices have a lot of what we call personal goodwill versus the restaurant, for instance, which we would consider something that has high enterprise goodwill. So these are important factors to consider when we value the business interest, because it speaks to the risk of maintaining and losing customers for the buyer going forward.
Internally, then the value from that risk, right? Because once that's
Yes.
one of the factors. And so there are certain circumstances where we can assure ourselves in the law firm context that that goodwill transfers, right? Because especially in the retirement context, if a attorney is retiring, we can make them of counsel. We can keep their name, if they are of counsel, and we can bind them to, transitioning clients and referral sources over to the firm.
Yes.
So, but when an attorney is leaving and setting up a new practice 2 doors down, then the exact opposite occurs. All of that goodwill leaves the practice. So understanding those factors is really important. Now let's talk about the difference between enterprise value and equity value, right? And so the example I always give in this area is your home, right? So you go out, you buy $1 million home. Well, if you got an $800,000 mortgage on that home, your equity value is $200,000. It's not $1 million, right? And so the same thing applies in the context of your firm or your business, right? And that is, if I acquired the practice and I got a loan for $900,000 and I put $100,000 in, well, until I start to build that practice back up, right, and add value to it, I only have $100,000 equity in that firm. So if I'm bringing somebody on board into that firm as a partner, I've got to consider the liabilities that are sitting out there and in terms of determining that value, right? So the going concern that you're coming up with may not necessarily be the deal that we're doing, right?
Absolutely. We consider all of the liabilities that are attached and associated with the business going forward with the present value of the business interest. The interest we're valuing is the present value of the anticipated future cash flow. So those liabilities and those risks to any future buyers all have to be considered in the present value of the business interest.
Excellent. So as we're looking at this, right, you had mentioned before discounts for minority ownership and lack of marketability. And so tell me about those and how they play into this.
If somebody is, it usually a lot of times from the 20,000 foot view, if we're doing something for gift and estate tax purposes, we are allowed to take, the IRS allows discounts for lack of marketability and lack of control for minority interests, and that greatly reduces the tax impact on those interests. And when we've got a minority interest in a business, for instance, when a business owner wants to gift a particular amount of shares in his business to an employee or to a family member, we can discount that for tax purposes as a gift. So it does come into play. On the other hand, we don't say then that they only get that discounted portion. They get the full amount of shares and they share in the profits and losses of the business. But for those tax purposes, we can take those types of discounts.
So just want to clarify one thing, definitely in the context of gifting to family members or whatever, but typically and I just want to make sure that everybody hears this, typically you can't gift things to your employees, right? Because at the end of the day, the IRS would look at that as a disguised compensation, and that would be taxable to the employees. So if I have $1 million practice valued $1 million and I'm giving a 10% interest to my employee, well, I've given them somewhere between $100,000 and a $65,000 compensation for which taxes have to be paid, withholding has to be taken, right? And so at the end of the day, if it's valued at $100,000, it might actually mean that there has to be an extra $30,000 plus or minus of cash that then is paid off to the IRS for purposes of those taxes that become due. Now, who they come from, that's a whole issue separate and apart. So, okay, good. Good, good. All right. In all of this, right, we're talking in the context of the disaster, the landmine that blew up on this surgeon, right? And so I just want to talk about how to avoid that landmine. So what are the things that the listeners need to do today if they have a partner and a partnership agreement, whether that's a shareholders agreement or an operating agreement or a literal partnership agreement? What are the things that they need to do today?
We want to look at the mechanism. Oftentimes, I see a lot of agreements, or I get calls and they tell me, well, listen, we have a partnership agreement, or there was a prenuptial agreement, and both sides in this partnership divorce, for instance, said they have to each go out and get a valuation. So do we really need to do that? I think is one of the issues. Do we really need to get two valuations or business appraisals, depending on the circumstances? Or can we start with just one? People who are business partners who are buying and selling interests among partners, if it's friendly and they're on the same page and there's no issues, I recommend that they just get one business appraisal. And then if there's an issue with it or somebody takes issue with it, go ahead and have another appraiser review it to get a second opinion. But oftentimes I have seen partners in a business, for whatever reason, getting along just great, but then they need to do a valuation. They run to two appraisals, they get two different values, and then there's a deterioration in the relationship. And obviously, it gets more and more expensive.
Yeah.
So it's less expensive if everybody's on the same page to just start with one, if possible.
Well, I will go further than that, Matt. I will go and I will say that you should never have more than one appraisal in the agreement. It is way more important that you specify the credentials of the person who's doing the appraisal, because if you specify the right credentials, like an ASA senior appraiser, or in the context of real estate, an MAI or an appraiser who holds the MAI designation, at the end of the day, you're going to get a quality product, right? And so the idea that now we're going to pay for two, knowing that they could be tens of thousands of dollars. And then when those two differ, what are we going to do? Well, we're going to get a third to come in and take a look, and another tens of thousands of dollars. And then in reality, all of those people have to negotiate amongst themselves to come up with the real value. What are we doing? We're creating this enormous level of complexity, and it really doesn't need to be there, right? Because I think you've got a good story about a situation where two appraisals were needed, and you were one of the appraisers.
Yeah, and it was a situation where, fortunately, the partnership agreement said that two appraisals were going to be required. It was a divorce situation, and they needed to be done by an ASA. So the phone call I got was from one of the attorneys in the divorce case, and he said, I didn't even know what an ASA was. I had to look it up, and then I found you because you were one of the closest ones to me. So I need an ASA expert. Can you do this assignment for me? It was an extremely complicated assignment because the husband and wife had a prenuptial agreement. There was multiple businesses on the husband's side, but the husband and wife had a business, a smaller business that had commercial real estate, had an operating business, had agricultural properties, multiple parcels scattered around Florida. And it was quite challenging because for citrus properties, we had to determine, is this basically gone and is this just going to be vacant land? Do we value it there? Is this really developable? Is there a higher and best use for the citrus properties that were in somewhat decent shape? Can we bring these back to full production? Then there was production, and then there was the commercial real estate, but it was kind of vacant because the business that was in it was leaving, and because of neglect, the operating business was. So it was very, very complicated, or complex is a better word, as we had to put a value over all these different assets that were unrelated under one umbrella. And the other side hired an ASA out of Tampa. And after 6 months of each of us working on the assignment, and the conclusions came in, and I'll admit I was very nervous that we were going to be tens of or hundreds of thousands of dollars apart. And it turns out we were only $1,600 apart on our two appraisals. And of course, his report and my report, each report was 120 plus pages long, and we were only $1,600 apart. And the reason for that was because we were both ASA, accredited senior appraisers in BizVal with the American Society of Appraisers. We had been taught and trained the same way to attain that credential. And because we followed the same methodologies that we had been trained to in each one of those different elements, the appraisals came out very clearly. Now, sadly, the couple fought about the $1,600 for another 6 months, but the two appraisals, because we were both ASAs and followed the same methodologies, came in that close together, which saves the shareholders a tremendous amount of money and fighting on additional insights and discussions and negotiations and such.
Excellent. Excellent. All right. So I want to just wrap up with a couple of takeaways here, right? So a couple of things. The first thing is, if you only look at your partnership agreement when the need arises, it's going to be too late, right? It's going, yes. You're going to look in there and go, oh my God, I shouldn't, what did we agree to? What did we put in this thing, right? So the takeaway here is to get out your partnership agreement. It's probably buried somewhere because you haven't looked at it since you signed it, and actually read, what is the measure of value? What is the measure of value on a buyout? Now, remember that the circumstances of the buyout really impact this in a big way. And so you may find that if somebody is leaving on bad terms, they've done something wrong, right? In the lawyer context, they've been disbarred by the firm. Maybe there's a haircut. Maybe that's a reduced price. Maybe that is the book value in that case because you're causing reputational harm to the law firm, right? Something along those lines. Or in the context of death, what is it? Should it be fair market value? Should it be something less with the acknowledgement that your production is going to go away and your potentially your referral sources and all of what you bring into the firm is going to go away? Should that be the case? And what happens in the case of disability or retirement? So look at it, map out what's going to happen, and write it out, for yourself. Just bullet point the thing out. And then just remember that no partnership agreement ever got better with age. It is a living document. Things are going to change. And so at the end of the day, you should be revisiting that thing every 5 years. It should be something that comes up during an annual retreat where you talk about, hey, does this still work for us? Is this something that we want to have happen? And if it does, great, wonderful. You don't have to make any changes. But businesses change, right? Law firms change. Yes. Things happen. And this agreement should keep track so that, again, like I said before, it's not treating the law firm like it's a startup after 5 or 10 years of being in practice, right? It's an actual ongoing business. So do that for yourself. If that's the only thing you do out of this, do that for yourself. But I will tell you that these are complicated documents and we're here to help. So if you need help, just give us a call. You can call us at the office at 407-649-7777, and we will be glad to assist you in the process of reviewing that. And you can also download, if you go to the website, alexanderbusinesslaw.com, you can download our partnership guide. It's right there in the books and guides section. It's a free download, and you'll find all sorts of information in there that will assist you well beyond just this value conversation. So Matt, I want to say thank you for joining us today. I appreciate it. And I look forward to our next get together.
Thank you, Ed. It's always a pleasure to be with you. It's always great to talk about these subjects. And thanks for all that you do and all the people that you help navigate these through all of these things that we've been discussing, because they're real and everyone's going to face them at some point. So thank you.
Thanks.